Judge, it's our position that this is obviously an important decision of the court, but it's a straightforward analysis under the binding decisions of the Florida Supreme Court in De La Rosa and Roberts, and of the second DCA in the Fegan case that we provided to the court. It's now indisputable that Juror 15 gave dishonest answers and incomplete information to the court in response to the questionnaire and during voir dire. Based on that information, Ms. Benefield and her attorneys were not able to make an informed decision as to whether they would exercise a peremptory challenge to her serving on the jury. And the second DCA in the Fegan case says that a defendant has an inalienable right to make a peremptory challenge based on full knowledge and a complete disclosure by the juror. And Mr. Taylor's correct. Whether Juror 15 did it intentionally or not is irrelevant under the case law. It's the effect on the defendant and her ability to make an informed decision about a peremptory. It's our position that the most egregious of the omissions by Juror 15 was her failure to acknowledge that she had been involved in domestic violence court. At the subsequent hearing, she acknowledged she was the petitioner in a domestic violence petition, and the court has copies of that petition. At the top of the petition, it says, "Petition for protection against domestic violence," so it makes no logical sense. She wouldn't understand that. She was also, more importantly, the respondent in two domestic violence injunctions, also entitled on top, petition for protection against domestic violence. And in the second one, her husband, and they're both filed by her ex-husband. The first one was her ex-husband and her son, their son, and then the second was on behalf of the son. In the second one, the ex-husband specifically asked for custody and was awarded temporary custody of the minor child. So her answers that she did not know that she was involved in domestic violence courts are disingenuous and misled the defense in its decision-making process. Most importantly, the omissions are material, and there's a three-part test under De La Rosa. One of the elements is, did the juror conceal information? I think that's undisputed at this point. Two, is the information relevant and material to jury service in this case? And what the De La Rosa case says is, if a potential juror is similarly situated to the opposing party, then it makes reasonable sense that the other party will want to exclude that person for cause or a peremptory. Here, by being the respondent and allegedly committing acts of domestic violence in a family situation, accused of threats and misconduct, it is similar to the allegations that Ms. Benefield made against Douglas Benefield. So those particular, the fact that she was a respondent in those two cases makes her similarly situated to Douglas Benefield and makes it clear that had that information been properly disclosed, Mr. Taylor and Ms. Benefield would have been suspicious of her, believed she may have been biased, and would have exercised a cause or a peremptory challenge. The third factor was the failure to disclose the information attributable to the complaining party's lack of diligence. And those cases discuss the sufficiency of the questions asked by the lawyers. And as Mr. Taylor, I think, adequately indicated, the questions in this case could not be any more clear. Have you been a victim of a crime? Were you involved in domestic violence cases? And have you been involved in a dispute about child custody with a significant other? There's nothing about those questions that are unclear And if you look at the Roberts case,
Got it.
in that case, they just asked about litigation. And the lawyer, the juror, potential juror, apparently explanation was that they didn't specifically say domestic assault or injunction, but they just said litigation was enough. Here we were more specific. There was domestic violence, course, and custody. In the Taylor case, Taylor versus Magana,
Yes, sir.
under head note 11 of the opinion, they found that the questions were satisfied the due diligence inquiry because they were specific, unambiguous, and not cluttered with sophisticated or confusing legalese. Again, the questions here could not be more clear. It's our position that we've established the three-part test under De La Rosa. That shifts the burden to the state to show that any error was harmless. Under the facts of this case, they cannot meet that burden, and it's our position that the court is required by De La Rosa, Roberts, and the Fegan case to grant the motion.
Thank you, sir. State